Hey, Paul here, and in this video, I'm going to address the 10 items that married couples really need to discuss before they meet with the estate attorney. So I've helped thousands and thousands of clients over the last 30 years get and keep their legal affairs in order, and I'll be the first to tell you that everybody's circumstances are different. Every family is different, every family tree is different, the objectives that each individual or couple is hoping to accomplish can be different. What people own is different, but there are some common threads that virtually every married couple, this will come up as part of the estate planning conversation. And I also realize that sometimes it's better if those things are discussed prior to meeting with the lawyer rather than the lawyer springing this issue on you and you have to make a fairly quick discussion in the presence of the lawyer. And it may be a conversation that's better had privately outside of the presence of the lawyer. So I want to go over with you 10 things that really every married couple should discuss. It'll save time, it'll save effort. Like I said, it can save you having to make a quick decision in the lawyer's office and then, driving home or the next day you're with your spouse and you say, you know what? I know that we said this when we met with the lawyer, but as I think about it a little more, I think we should have done this. So if you can address these 10 things, it may save a lot of time, and it may make sure that things go exactly how you want them to go, which could affect your family for generations into the future. Okay, so I'm going to hit on these 10, and kind of an oh, by the way, I'm going to give you the 10 items fairly quickly. And then in the coming 10 days, I'm going to take each one of these items and do a deeper dive in another video. I know a couple of videos ago, I said I was going to take a break from doing the daily videos, and here I am, 3 or 4 days later telling you I'm going to make another 10 daily videos, but I can't help myself. I enjoy making these videos, and from reading the comments, it looks like I may be helping a few people, so I'm back at it. So this is the 10, and then in the 10 subsequent videos, we'll break each one down. So I'm going to go through them fairly quickly, but these are things that you should discuss. And quite frankly, if you even don't watch the future 10 videos where we take a deeper dive into each item, this one's really going to help you. Let's jump right in with the big ones. And this is for married couples. The first item that you should discuss prior to meeting with the estate attorney is what happens when one of us passes away. Honey, when I'm the husband, I'm probably going to die first. I want to talk to you about how I want to leave things when one of us passes away. Do we want to leave it where we just leave kind of ownership and complete 100% control to the surviving spouse, or do we want to put some protections in place for the children to make sure that they get the first spouse to die share when the surviving spouse dies? And the husband might either jokingly or in all seriousness say, what worries me a little bit is if I die and leave everything to you and you get married again, or if someone in your older age successfully attempts to adversely influence you, our kids may wind up with nothing. So maybe we should put some things in place. Perhaps we should, when one of us dies, that spouse's estate goes into a trust for the surviving spouse to use for the rest of their lifetime. And when the surviving spouse dies, things revert back to the children. So that's one of the things that married couples should discuss. Number 2 is, honey, how should things go after both of us pass away? And I'd say by far the most common answer to that is we want things to go to our children equally. But there's also some other, common situations where people want to provide things for their grandchildren. People sometimes want to make specific bequests because of the family circumstances. Maybe the house should go to this child, or could be a number of different circumstances that would warrant something other than the children equally, but the children equally is common. And then number 3, can our heirs, honey, is it okay if we just leave it to them, what we call outright, so they can do whatever they want to with their inheritance? Or because of some unique circumstances, it should go into a trust for them after we pass away, so that either they don't have the ability to blow it, their government benefits are protected, their spouse who we don't like won't have any influence over it. So that's another, item number 3 is whether you're comfortable just leaving the assets to your heirs outright or whether it should be in a trust for them. Item number 4. Who's going to handle all this when we pass away? We're going to have to designate some person or some people to make sure that everything goes exactly how we have it spelled out. We may get to the titles executor or trustee in a minute. But, couples sometimes struggle. Some couples will say, well, let's name Jack because Jack's responsible. Jack's, good with financial things, and he has a good relationship with all of his siblings. Jack's the obvious choice. Let's pick Jack. And others will say, I don't want the others to feel like, we like Jack more. So let's name, all of our kids to fill that role. So that's a conversation that couples have to have and couples have to decide. Item number 5, what do we do with all of our personal effects? And there's really 3 ways. This is the non-titled personal effects, not necessarily the stuff that has tremendous fair market value, but stuff that has more sentimental value. So, you'll probably come up with one of 3 answers to what do we do with our personal effects after we're all gone. First option, let our kids figure it out. Second option, let's maybe have this side letter, this kind of non-binding letter that where we just put our preferences and what we'd like them to do and maybe who we'd like to get certain things, and then they'll honor our wishes if we just communicate it to them. So that's the second option there. And then a third option is, no, we better put this stuff in the legal documents because we don't want there to be any question or any argument. Let's put the disposition of at least some of our personal effects in our legal documents. So there's another conversation that married couples should have. Item number 6. 1 through 5 has been what happens when we die. Now we'll get into some of the what happens if we're alive, but we're out of it. So item number 6 for married couples to discuss before they meet with the estate planning attorney is, honey, who should handle all of our money if either we're both in a condition where we can't make our own decisions and sign our name, or when one of us dies and the survivor of us does not have the capacity to handle all of our financial transactions and our accounts. Who do we want to handle that? So that's got to be a decision that you'll make. And number 7 is similar, is, honey, if we are in a surgery or if we can't talk to our doctors or if we have dementia and we're not in a condition to be able to make our own, routine day-to-day medical decisions, or if we're in a surgery and the doctors need to talk to somebody, who do we want having that ability to do that for us, either for both of us or for the survivor of us if we're not able to make those healthcare decisions for ourselves? Item number 8. Honey, how do you feel about us having a living will where we state our wishes regarding the withholding or withdrawal of life support machines if we're a vegetable with no chance of recovery? Do we want to relieve our kids from having the burden of having to make that decision to terminate our life if we're a vegetable with no chance of recovery? Or do we want to make our wishes known clearly so that our doctors and our family know what we want and they'll just be honoring our wishes? And then item number 9 might be a conversation like, honey, before we go see the lawyer, let's talk about whether we'd want to leave things to each other and to our family through our wills or through a living trust. And that conversation outside of the presence of an attorney might sound something like, I've heard, and with the limited research that I've done, if we keep everything in our name and we leave everything kind of the traditional way to each other and to our kids or our family through our wills, there's going to be a probate when each one of us dies because assets are going to be frozen and our survivors are going to have to take our will, hire lawyers, go through a court process, and have judges order that assets be transferred out of our name. But honey, I've heard about this concept where we can create what's called a revocable living trust. We can title things in our trust. Things in a trust don't go through that court process when we die. It eliminates the court and attorney involvement. What do you think about that? So that's item number 9 of the 10 items of things that married couples can discuss prior to meeting with the estate planning attorney. And then the number 10 is, honey, how do you feel about, our future long-term care, those skilled care needs that we might have in the future? Maybe the couple is saying, we're 65 years old now and we're in good health. But, before we know it, we could be 85 and really need some help with those, activities of daily living. So maybe you'll have 3 options there. Maybe you'll say, you know what, honey, we've been saving, we're frugal. We're going to have enough money to be able to, self-insure or privately pay for that kind of care in our future. So let's just count on that. Or you might say, perhaps we should look into some of the insurance options that are available to cover that care if we need it. Or if neither of those are an option, you may have to say, honey, we need to be prepared to talk to that lawyer about taking the legal action that we need to take to protect what we have. So if we go to a nursing home, we don't lose everything. So those are the 10, and I'm going to make you a hero right now. I promise you I'm going to make you a hero in somebody's eyes, because every couple has to have this conversation, and they're either going to be forced to have it in the attorney's office, or they're going to watch this video and they're going to be better prepared to have the discussion when they do start to get their legal affairs in order. My suggestion to make you a hero is just share this video with another couple that probably needs to have this conversation. You can share it probably right there on your screen. There's a share arrow or a button, and then you can either text message this video or email this video or copy the link and send it to somebody else. And maybe even along with a little message. Hey, thought you might saw this video, thought you might like it, thought you might find it helpful. They're going to tell you, thank you so much for sending me that video. It's stuff we've been putting off. We've been meaning to go see a lawyer, but we didn't know enough to know what to even ask. And by watching this video, you will be better prepared, and the people that you share this video with will be better prepared, more comfortable about at least initiating that estate planning conversation, which again, by initiating it, that will trigger a process that could, really help the family for generations into the future. Okay, so I wanted to share those 10 with you. Look forward to the next 10 days. Got my work cut out for me of taking a deeper dive into each one of those 10 items that married couples need to discuss before they meet with the estate planning attorney. I'm Paul Rabelais. We'll see you tomorrow.